Bombay High Court pulled up a lawyer for approaching the personal secretary of a judge trying to get an order modified surreptitiously without informing the other side in the case. The bench of Justices G.S. Patel and Gauri Godse issued a stern warning if the offence was repeated again. Advocate Sachin Tigde, who represented a real estate company in a case against the Maharashtra government, had allegedly approached Justice Patel's private secretary who had taken dictation in court and asked him to modify an order dictated by the court. After a hearing on August 4, the bench had granted liberty to the petitioner to withdraw his petition challenging a demand raised by the state. Tigde, during submissions, had requested the court to allow deposit of 50% of the total demand raised, which the court refused. On instructions, Tigde stated he would withdraw the petition and hence the submissions made by the lawyers were not recorded. Later that evening, Tigde allegedly asked the private secretary to include in the order a direction for a 50% deposit. When Justice Patel was apprised of this, on August 5, he asked Tigde to explain his actions. Tigde, however, had no answer except an apology, which the court refused to accept as it seemed insincere. It is not sincere and it is offered only because we have taken the trouble to list the matter and pointed all this out, the 4-page order stated. The lawyer then explained that he sought clarification on what the order included. However, the court said, there could have been no reason to seek such clarification. The order was pronounced in open court and, whatever else may be said about us, no one has yet said we are inaudible. No such clarification could have been sought from our secretarial staff. It could only have been sought from court on an appropriate application. The bench further said that had Tigde succeeded in his endeavor then, not only would the respondent have been prejudiced, but its advocate would have been perfectly justified in complaining that an order was changed to something totally different from what was dictated and pronounced in open court. And our secretarial staff might well have lost their jobs. As a precautionary measure, the bench also directed that a copy of their order be sent to the Registrar General to issue appropriate instructions to all secretarial staff to not entertain requests from advocates and litigants henceforth.